Support Center. We are here to help all of you with counsel, with help you with advice on your cases or questions that you might have, as well as co-counseling litigation, assisting with administrative advocacy, and doing legislative advocacy. So please feel free to call us with your public benefits questions. That is where we focus: CalWORKS, CalFresh, General Assistance, SSI, CAPI, etc., in-home supportive services. But we also do trainings for all of you, and we are available for trainings for your individual programs as well. If you want to contact us about doing that, we're happy to talk to you about doing that. But our program today, as I said, is about the Housing Choice Voucher Program, and I came up with the idea of doing this from when I was a staff attorney. I was a staff attorney for an attorney at various levels for Legal Services of Northern California for many, many years. I don't know if I need to say how many. And I had so many cases where I had public benefits issues, and the clients were also Housing Choice Voucher Program participants, and those issues crossed over in several important ways. And I had to navigate both of them at the same time for some of those issues. So we came up with the idea of doing this training as a way to introduce public benefits advocates to at least the issue spotting that we need when we're doing a benefits case that might also impact Housing Choice Voucher Program eligibility. So first, what is the Housing Choice Voucher Program? It was designed to assist low-income families to give access to affordable housing. The rent payments are from the client are usually 30% of gross income. It may be more, but it's capped at 40%. And the voucher itself is a portable subsidy that the tenant takes to a prospective landlord or for a property that they're already in. And the housing authority then pays a portion of the rent based on the client's income. It's different than public housing, which is a physical structure owned and operated by the housing authority. This is a subsidy that is brought to private landlords, and then the housing authority, based on the voucher amount, pays a portion of the rent to the private landlord. The Department of Housing and the U.S. Department of Housing and Urban Development sets forth the regulations for the HCV program. Those are the nationwide regulations, but the local housing authorities have their own regulations called the administrative plan, and we'll talk more about that as we go through. Public benefits practitioners. This is an important program for public benefits practitioners because it's an important related benefit for low-income folks who are receiving, CalWORKS or other benefits. If they've been lucky enough to get on the Housing Choice Voucher Program, it's kind of a related benefit. And the relationship with the housing authority is very similar to the relationship with the welfare department. The program uses income and asset rules, and things that will sound very familiar to you as a public benefits advocate. But the rules, of course, are not the same as for other benefits programs. So that's where people do sometimes need to be careful. So the rules for the Housing Choice Voucher Program, the nationwide regulations are found at 24 CFR Section 982. HUD has its own policies as well. The major one that HUD puts out is called the Housing Choice Voucher Guidebook, and it's updated periodically. As far as I know, it still exists, and as far as I know, it's still on HUD's website. And then the local housing authority that administers the Housing Choice Voucher Program for whatever area that you are in has its own rules that is called the administrative plan. And you'll need to look at both of those. You'll need to see what the local rules are if you have an issue and check those against the against the federal regulations, and the Housing Choice Voucher Guidebook. If somebody wants to apply for the Housing Choice Voucher program, the Housing Authority maintains a waiting list of people who apply, and there are preferences that people can have to move up the waiting list. For example, some housing authorities give a preference to folks who are currently homeless or persons with disabilities. The larger housing authorities in particular, it is very difficult to get on the waiting list. It will open, 1 or 2 days a year if somebody is lucky. And so people, if they want to get on that waiting list, really have to be watching to be able to try and get on. And then when a person reaches the top of the waiting list, the housing authority does an evaluation of eligibility, and that looks a whole lot like eligibility for other government benefits programs. And then if somebody is found eligible, the housing authority issues the voucher. Something a little different for the Housing Choice Voucher than other benefits programs is admission to the program can be denied for certain criminal activity, for bad tenancy history, or for prior debts owed to the Housing Authority. The only thing slightly similar in the benefits world is either the fleeing felon rules or for CalFresh, that really narrow set of criminal convictions that can cause a CalFresh issue. So that is something that is different for the Housing Choice Voucher program. And after the voucher is issued, the client has 60 days to find housing to rent. And so in practice, what happens is the voucher is issued to the tenant finds the landlord contacts the housing authority. The housing authority then sends a document to the landlord called the Request for Tenancy Approval, or RFTA. The landlord signs it. It's a sort of a triangular relationship. And then once all that's done, the housing authority will calculate the amount of rent that it pays to the housing provider, and the remaining amount of rent is the tenant's portion that they have to pay. And the relationship between the tenant and the landlord looks, at least for most purposes, like a regular landlord-tenant relationship, and that's not what we're going to be talking about today. And the relationship between the landlord and the housing authority, in almost every case, not our problem. The relationship we're focusing on today is that relationship between the tenant voucher holder and the housing authority. And so to be eligible for the program, eligibility is based on the client's annual income, and the amount of rent that the tenant pays is based on their income. The voucher amount increases if the tenant's income increases. If the tenant's income decreases, and the voucher amount decreases at the next annual recertification if the tenant's income increases. And so you'll see as we go through that there are very similar reporting requirements to the housing authority for income and resources and various other things that will sound very familiar to public benefits practitioners. And I'm not sure I said, please, if you have any questions, I can't see the audience right now, so please either shout them out, or we've got somebody watching the chat if you want to put a question in the chat. If a tenant's income decreases, that should be reported to the housing authority right away, and the voucher amount should increase right away. If the tenant's income increases, the housing authorities have some discretion about whether that's an immediate reporting or whether it's just at the next annual recertification. The recertifications are only done annually for the Housing Choice Voucher program. And so the eligibility, continuing about the eligibility and rent, the size of the voucher is based on the family size. So the voucher will have a number of bedrooms, and that number of bedrooms is based on the family size, and that says what size unit the family can rent. And again, the rent is based on 30% of the tenant's income. There is a maximum amount of rent that the housing authority defines. And if the tenant wants to rent a place over that, they can pay more than that, up to 40% of their income. At least for now, assistance is prorated for ineligible non-citizens. So if we have, for example, two citizen children and a non-citizen, ineligible citizen parent, then it would be a voucher for two people. And the non-citizen rules are similar to CalWorks and the old CalFresh rules before HR1, but of course they're not identical. So if you've, whatever the immigration status is, you do need to check and make sure what their eligibility for the Housing Choice Voucher program is. And I do say, at least for now, there are regulations pending. I believe the comment period is already closed. That would end this rule. And if there is any non-citizen, ineligible non-citizens in the household, then the entire household is denied. We'll see what happens with that. The asset limit is $100,000, the resource limit. Now, there's a little asterisk by that, which actually isn't on the slide. Sorry, it should be. And that increases by the cost of living every year. The star is this asset limit is from a law that passed several years ago called HOTMA. And there's various delayed implementation dates, and housing authorities has some discretion of when they implement it and how much they implement it, and it does a whole bunch of things. And so it is worth it, if you have a client that has an asset issue, to check your local administrative plan and see if the housing authority has implemented the HOTMA limit, and if they haven't yet, when they intend to.
There's a couple questions.
But go ahead. Yes.
So Kevin asks if they have a report form. And then Beatrice asks, is there preference for families with children who may be losing their home or going into foreclosure, or must they have lost their home to apply?
Kevin's question first. Every housing authority does that differently, whether they have a report form or not. There's nothing standardized from the federal government, and there is no like statewide umbrella organization. Each housing authority does those kinds of things themselves as they want. Beatrice, the answer to your question is it depends on the housing authority. Each housing authority defines their own preferences. It is not required that somebody be homeless when they apply. And like I said, you will have to look in your local agency administrative plan to know which preferences your housing authority, the housing authority that you're working with, has chosen to implement. Because again, there's the authority for the housing authorities to implement preferences, but there's no federal requirements beyond that, and there's no statewide agency. It's just what each housing authority wants to do. The next thing I want to mention is something that is different than any other benefits program, and I always have to look up this rule. It drives me crazy. If somebody has assets, luckily now it's over $50,000. It used to be a lot lower than that for the housing authorities that have implemented HOTMA. And it's not a resource ceiling, but if somebody is over $50,000 in assets, then the housing authority considers income from assets. And so if if it's possible to determine the actual income from the asset, for example, interest on a bank account with $60,000 in it, then that is what counts as the client's income for purposes of determining their rent. If the actual income cannot be determined, then the housing authority will impute income from the assets based on bank savings rate bank account savings account rates at the time. So luckily, it's pretty low. My memory, I've dealt probably the most with the Sacramento Housing and Redevelopment Agency, and theirs was, I want to say, like 1.75% for a savings account. But still, it's very important. Um, the resources do have to be reported, even if they're under the limit, because there is this rule about imputing income from assets, um, which can really get people into some trouble if they have not reported their assets. And so for the Housing Choice Voucher Program, again, the housing is owned and managed by private landlords, and then the agency enters a housing assistance payment contract with the landlord to pay part of the rent, and then the tenant is responsible for the remaining portion. One other difference with other housing types is the landlord cannot increase the rent without prior approval from the housing authority. There's supposed to be limits about that, but the landlord cannot just increase the rent. Once the tenant finds a unit, the owner agrees to rent it and signs that request for tenant authorization RFTA form. And California has a special rule about this, that the landlord cannot use a credit history without offering a chance to submit alternative evidence of the ability to pay. So that's a nice rule in California, um, for folks with lesser credit history, which makes sense for low income folks who are eligible for this program, that their credit might not be the best. So there's a chance to submit alternative evidence. The housing authority then inspects the unit, and they do annual inspections of the unit. The owner signs the housing assistance payment contract, and then the housing authority starts the payment after the tenant takes possession. After the initial lease term, and every housing authority has discretion to do that. Sort of the default is 1 year, but other housing authorities have a lesser time. The tenant can request a transfer, which allows the tenant to lease a different unit with the voucher. That's when I mentioned the voucher is a portable subsidy, so that if the tenant wants to move after that initial lease term, they can. The tenant has 60 days to lease up after the transfer is issued, which can be extended for good cause if the tenant is disabled. During the initial lease term, the tenant can only transfer for good cause with permission of the housing authority. And it is possible to transfer to another jurisdiction, have your voucher actually ported, it's called, to a different housing authority, a different jurisdiction, even a different state. That works just fine. Um, right now, there's a few issues with that because housing authorities are in some money trouble, and there are some that are not taking transfers. And so there's some issues with that. But in general, the rule is that it's a portable subsidy that can move to other jurisdictions. The recertification process will again sound very similar to dealing with annual recertifications or semi-annual recertifications in benefits programs. The tenant has to complete the annual recertification. As part of that, the housing authority does an annual inspection of the property. That is something different. And the housing authority can order repairs and actually stop payment if repairs aren't made. But it is at this annual recertification that the tenant has to report changes in income or household composition. And it's very important to look at your housing authority administrative plan to know if they have tighter rules for reporting. For example, Sacramento, you have to report everything within 10 days. And if you don't, if you're late reporting, it's considered a program violation, and they can move to terminate the voucher just for that. And here is a place where if you've got, recertifications happening for benefits programs and for other programs, the word income wouldn't it be nice if income for purposes of CalWorks or CalFresh and the Housing Choice Voucher Program, if all those definitions lined up? They don't. And so there are things that may very well be exempt for CalWorks or CalFresh, but count for purposes of Housing Choice Voucher or vice versa. I don't really have an example offhand, but this is where if you are helping a client with a CalWorks or CalFresh recertification, and they also have a housing choice voucher, you might advise somebody, you know what, I've looked at the CalWorks rules and whatever source of it, whatever type of income it is, it doesn't count for purposes of CalWorks or CalFresh, but look it up and make sure it might count for the Housing Choice Voucher Program. And it would be important to advise the client, hey, even though I told you I don't need to report it, you don't need to report it for CalWorks or CalFresh, you do still need to report it for your Housing Choice Voucher.
Stephen, there's another question in the chat.
Yes, please.
Juliana asks, or Juliana, sorry, if repairs aren't made after the annual inspection, does the tenant also have to move?
No, but what will happen is the housing authority will issue an abatement notice. They will give the landlord a period of time to make the repairs. And if the landlord does not make those repairs, they will stop payment of the subsidy. They will stop payment on the voucher until the repairs are made. And that puts the tenant in kind of a pickle because the landlord will often say, hey, I'm not getting the housing authority money, so you owe it now, and we'll move to evict for non-payment of rent. I think that's a great habitability defense, and there actually is a published case that says that the housing authority not paying because of abatement, that's not actually rent owed by the tenant at all. Yeah, based on habitability rules. But it certainly can make the tenant more than nervous. And so there's sometimes some negotiations with the housing authority about, do you really want to abate this? Let's work out something so the tenant isn't put in danger. I hope that answers your question. Let me know if you have a follow-up. And so there are limited grounds for terminations from the Housing Choice Voucher Program, and they are listed. They are what are called program violations, and some of the major ones that will sound very similar to government to other benefits programs are not reporting income, not reporting resources, not completing annual recertification. There are other things that won't sound so familiar, like an unauthorized occupant in the unit or an allegation of drugs on or near the property, things like that. Things that sound more like housing issues than benefits issues. But there's a bunch of things that sound a whole lot like benefits issues. And the housing authority has to give the participant written notice of the proposed termination. That's almost identical to government, to other public benefits programs. The notice needs to state the reason for the termination and the facts supporting the termination. And some of those grounds, I mentioned a few of them, but serious or repeated violation of the lease, which includes non-payment of rent, not providing required information, is one of those things that sounds more like a benefits program. If the tenant gets a notice of termination of tenancy and forgets to give it to the housing authority, that is enough to get them terminated, actually. Having an unauthorized guest or tenant engaging in drug related or violent criminal activity on or near the property not including being a domestic violence victim. There's a whole separate process for that. If somebody is evicted from the unit, their voucher is also terminated, which puts people on the eviction defense side of this in some difficult choices to make, because the stakes for attempting to defend against an eviction are even higher. If somebody loses, they don't just lose their tenancy, but they lose their voucher too. And so that can be a very difficult situation. Damage to the unit caused by the tenant, alcohol abuse that threatens health, safety, or quiet enjoyment or other tenants, an extended absence from the unit, I think it's 60 days. Fraud in connection with the program, that sounds like public benefits. Overpayments are similar to public benefits. I'll say something about that in a minute. And side payments. That is, if the if the tenant is making payments over and above what their tenant portion is, that's actually a violation of the rules, and the tenant can be evicted for it. And then that termination notice has to state the reasons for the termination with enough specificity to prepare a defense. That should sound familiar. The family's right to an informal hearing. We'll get to that in a minute, but that will also sound familiar. And the date by which a hearing request has to be made. And that's going to be different for every housing authority. So if there is a housing authority, if the housing authority moves to terminate the voucher, the tenant has the right to an administrative hearing. They call it an informal hearing. There's something called a formal hearing for public housing. And I've never really noticed that much of a difference between them, but so be it. And the housing authority has to provide the opportunity for this informal hearing, an administrative hearing, before the termination of assistance. The time frame for doing that is different for every housing authority, so you have to look it up. It's kind of the best benefits analogy is to general assistance, that each county has their own rules, each housing authority has their own rules for that. The tenant has the right to bring evidence, witnesses, and be represented. The tenant has a right to view and copy any documents or evidence that the housing authority intends to use at the hearing. That is something that's narrower than the benefits context and is very annoying to me. There isn't necessarily a right to the entire case file. You have to ask for it. And if the housing authority wants to give it to you, they will. But the actual requirement is only to get the documents that the housing authority intends to use at the hearing. And then the hearing officer has to be, cannot be the person who made the decision or a subordinate of the decision maker. Only issues in the notice can be raised, no rules of evidence. There has to be a written decision provided to the housing authority and the tenant, and the decision must make findings of fact that are adequate to support the decision. Again, this should sound very familiar to a CalWorks or CalFresh or General Assistance Administrative hearing. And then let me mention two other things here that I don't necessarily have slides on. There is the right to file a petition for a writ of administrative mandate, judicial review of a housing authority decision. Housing authorities are county agencies, and so they are governed by Code of Civil Procedure Section 1094.6, which means there is only 90 days to request to file a petition for a writ of administrative mandate. The decision, however, is required to inform the program participant of that deadline to file a writ, at least in theory, and there's some pretty good cases supporting it. If the hearing decision does not inform the tenant of the 90-day deadline to file a writ, the 90 days doesn't begin to start. I would not recommend using that unless you absolutely have to. But if things have gone wrong, let's say the tenant comes to you more than 90 days after the decision, um, that might be a way to be able to do a petition for writ of administrative mandate even after the 90 days. And let me mention the something more on the landlord-tenant relationship side. Things that are not different at all between a regular landlord-tenant relationship and a voucher tenant. Our security deposit is the same. Prohibited terms and conditions of rental are the same. The limits on landlord entry to the unit are the same, and the way personal property has to be handled after the tenant vacates, that's all the same. Some things that are different. The housing authority determines the maximum amount of rent, and the housing authority cannot raise the rent without approval of without the tenant's approval, without the landlord cannot raise the rent without the housing authority's approval. There are no side payments allowed, so the landlord cannot demand rent over and above the tenant's portion. And if the tenant pays it, they can. I mentioned that was a program violation. The landlord cannot require renter's insurance. And I say that based on a not so new now HUD memo, and who knows if HUD would still back that up. But if they, assuming they would, there are actually two of them that housing choice voucher landlords cannot require renter's insurance. And the HAP contract determines other payments, such as utility payments. And so things like utility payments is a good example. The landlord cannot charge utility payments or various other types of things that they might want to charge unless it is included in the HAP contract. And there's actually a pretty recent decision out of the Eastern District of California in federal court that demanding such payments that are not allowed, that are not included in the housing assistance payment contract, is a false claim and actionable under the Federal False Claims Act. It's a very good decision. I should remember the name of the case, but it actually, dare I say, it started with me. I referred the case to private counsel because it got too big for me pretty quickly. Um, but my client wound up not being the lead plaintiff, and so I don't remember the name of the lead plaintiff, but I do remember that the opposing party was Wasatch Property Management, if you wanted to try and find it. Again, on the landlord tenant side, landlord's evictions of a housing choice voucher is a little different. There's a required 90 days notice to evict without cause after the initial lease term. For other types of tenancies, 90 days is not required. I have a question mark there whether if the landlord has cause, whether they could give a shorter notice, 30 or 60 days. I kind of think not, but there are some people who think, particularly landlords attorneys, who think yes. And then during that initial lease term, the tenant can only be evicted with good cause, and the landlord can still give a 3-day notice. So if the tenant doesn't pay the rent, they still get a 3-day notice to pay rent or quit. If there is something that's subject to a 3-day notice to perform or quit, or a 3-day notice to quit, then those are still permissible notices. I'll also note here, again, getting into the weeds a little bit on the landlord-tenant side, the Tenant Protection Act um, at least as of now, is considered to apply to housing choice voucher tenants. There was an issue about that for a while after the Tenant Protection Act was passed, but there is a very good Attorney General's opinion um, that takes the position that the Tenant Protection Act does apply to housing choice voucher tenants. And let me say one more thing before I open it up for questions. One other thing that is very similar to government benefits programs is overpayments. And yes, housing authorities will pursue overpayments. Um, if there's unreported income, for example, they will pursue they will terminate for it, and they will pursue overpayments. One thing that is a little different on the overpayment side is it is possible to make payment plans with the housing authority to pay a certain amount or pay a certain increased amount of rent, or pay back the housing authority for the amount of an overpayment over a period of time. Those rules are pretty permissive. And so it's kind of difficult to force the housing authority to agree to a payment plan as opposed to just terminating the voucher. But there is a federal regulation on it, and each of the housing authority administrative plans should have rules about that. And if the housing authority does have rules about that, at least under certain circumstances, a payment plan is required, then they do need to follow those, and that would be something that's enforceable. Also, if there is a debt that's owed to the housing authority, I mentioned it briefly before, that can be a bar to future uh, to future benefits from the housing authority, either housing choice voucher or public housing if somebody were to try and move into public housing. And the housing authority can deny that if there is an outstanding debt that hasn't been paid. So, and again, getting a little bit into the weeds here, it's it's a very split issue whether bankruptcy gets a tenant out of that, whether the housing authority can still use it against them, even though the tenant is no longer legally required to pay it. There's I think 6 decisions nationally, and there is a big split amongst the decisions about what happens in a bankruptcy situation. But there certainly is the right, if somebody disagrees with an overpayment determination, there is the right to the administrative hearing, just like on the government benefits side. Um, Somebody can challenge an overpayment allegation from the housing authority at an administrative hearing. And let me pause there. I hope people have questions. I'm going to stop sharing.
And if you have questions,
That
just
is a
oh, sorry. You can just go ahead.
basic overview.
Sorry.
Go ahead. Do people have questions or other areas you would like to cover about housing choice vouchers?
And you'll have to unmute yourself. The
Oh,
attendees
that would
come
help.
unmuted. No, not you, Stephen. The attendees.
Oh, okay.
Yeah. So if you have a question, unmute yourself and ask away.
Let me mention as well. Also similar is folks who are in public housing. And public housing also has income and asset rules, which I didn't go into in detail. But again, wouldn't it be nice if those were the same as other programs? They're not. They're not the same as the Housing Choice Voucher program. So if you've got an income or assets issue, um, and somebody is in public housing, you'll need to check those rules There's federal rules about that, and on the housing authority side, it's called the Admissions and Continued Occupancy Policy, the ACOP, and those will have the local rules that implement the federal rules. And again, you might have situations where you have a certain type of income that is exempt for, or that doesn't count for, say, CalFresh, but it might count for public housing as well. And so, again, when you're advising people, particularly about income and resources, it's important to make sure if people do have a voucher or if people are in public housing, check that and make sure the advice is the same because it may not be. And I've got two questions in the chat here. Kathy asks, with rent prices soaring, how often does the HA actually approve increases in the payment standard? Um, that's hard to say. Each housing authority is different about that. Um, that's really hard to say. They are supposed to look at it annually, and there's a formula they are supposed to use, but I'm not sure. In my experience, it's been really mixed with the different housing authorities that I have dealt with. How often they actually look at that. I wish I had a better answer for you, I'm afraid I don't. And Heather asks, when children turn 18 but want to stay in the unit with their parents, what happens? Does everyone need to move out of the unit if it is no longer the correct size for the number of people on the voucher, or just pay the difference? What if moving is financially or physically difficult for the voucher holder? There shouldn't be a need for any change when a child turns 18. Now, the tenant, the voucher holder could request a larger unit because somebody has turned 18, but probably it wouldn't make any difference anyway because housing authorities already have occupancy standards and they require, for example, children over a certain age, and the housing authorities all do it differently. So I'm just have to say a certain age have their own room, and they do require that children of different genders have different rooms, and so more than likely, a child turning 18 is not going to change the voucher size. More than likely. I will note here because it comes up a lot in the context of trying to get additional bedrooms. Housing authorities, like any other government entity, are subject to the Americans with Disabilities Act and the Fair Housing Act. And so it is certainly possible to request reasonable accommodations, just like we do on the government benefits side, on the cash aid or on the CalWorks or CalFresh side. If we need a reasonable accommodation to turn in a recertification late, or for various other things, the rules are the same and should apply to housing authorities. And one example of that is if somebody needs an extra room in their voucher, either for a live-in aid or for equipment that they need because of a disability, that is a valid, reasonable accommodation request. And Kathy says, we've seen instances in which HAs say the living room should be used as a bedroom and have denied increase in voucher size. Yes, Kathy, there is a terrible HUD memo about that. I personally litigated it, I think 3 times, and I lost all 3 times. It's an awful policy. In order to get around it, there has to be some reason why the living room is not an acceptable living space. And I've been able to do it. I've won it a couple of times when a child had to have a room with a door that closed because of their disability. I was able to win that, but absent something like that, unfortunately, housing authorities can do it. It's one of the more frustrating housing authority policies and very disappointing HUD policy about that. Heather, you asked where. I'm not sure what you mean. If you want to come off mute.
We we can hear you.
Which counties? Well, unfortunately, the policy about that the living room being used as a sleeping space, it's a HUD policy, so it's a national policy. I'd have to go back and find it. It's several years old now. If people were looking for it, um, but it probably is on HUD's website somewhere.
Is there a local option to exercise it?
Um, Not really. HUD has come down on counties for giving additional bedrooms when the living room could be used as a sleeping space. So counties, there are some counties who want to do it, and they've told me that they want to do it, but they're afraid to. Any other questions? Anything else you'd like me to cover about this? I mean, I will say that's just an overview, just like, we could give an overview like this for CalWorks or CalFresh, and the devil is always in the details. Um, and so you do need to look things up. But hopefully, this is enough to be able to do some issue spotting and to recognize when in your benefits cases there might be a crossover issue with vouchers that you need to be careful about. Thank you very much. And there's going to be a brief survey after we end the training. We really would appreciate it if you could complete that survey. Let us know how we can do better in our trainings and what you liked too. And we'll hopefully keep doing the things that you like. Thank you very much. I'm happy to stay on if people have questions that you don't want to ask to the entire group. Thank you.